What we're going to do today is we had felt it helpful to have a meeting prior to the session beginning. As all of you, of course, know, we do not take action today, but I think we've got a couple of bills, actually 3 bills on the agenda that I thought would be good for us to at least have some discussion about. We do not have a sign-up sheet. I'm not sure yet that we're going to hear public testimony on any of the bills today, and the reason for that is primarily timing. There's a meeting on the proposed statewide water plan immediately after lunch, and I know some of the members want to go to that, so we're going to shoot to finish our work here by no later than 11:30 this morning, so that people can get lunch and go on to that meeting if they so desire. And of course, we'll have all of these things back on the agenda come the week of January 14 or shortly thereafter. If it turns out that we have time, then we may open it up for some public testimony, but of course we certainly will be hearing public comment on all of these proposals when we start the session. Let me thank all the committee members for being here today. I've missed all of y'all over the interim, and that was another reason for calling the meeting, was just to get everybody back together. But thank all of you for taking time out of your schedule. I know we have 1 or 2 members that are en route and will be here later on. We're going to start with Representative Everson's House Bill 92, which was a bill we took up last session, and Representative Everson asked to be heard on that. I think he's made some changes on that. So recognize our colleague on the committee.
Thank you, Mr. Chairman.
Let me, before you begin, when I indicated that we didn't plan to do public testimony or public comment, that's not to preclude members of the committee. I'll stay here all day for members of my committee, okay? Questions and comments and so forth. Thank you for letting me interrupt you. The floor is yours.
I guess I'm on, but I don't have a red light, but I'm on. Okay. Thank you, Mr. Chairman. Members of the committee, once again, I come before you with House Bill 92. You all are very familiar with this bill. It passed out of the subcommittee and full committee last year. Bipartisan support, ended up in rules and did make it out of rules because of some concerns. Before you, I have substitute to House Bill 92. We made a few changes there. In essence, what this bill does, it repeals a law that states that tattooing or permanent cosmetic technician tattooing 1 inch above the eye socket will become lawful. It was enacted a couple of years ago. Citizens of Georgia are very much in favor of this bill, because when an individual endures cancer treatments, they lose a great deal of their facial hair, and this bill allows those individuals that are trained and certified to perform that surgery to give those individuals some sense of normalcy as far as their facial features. And I respectfully ask that you support this bill. Of course, this is, as I say, the substitute to the original bill. And after this substitute bill was drawn up, I was made aware of some additional, one additional concern. I'm going to have to go back and do some additional work on this piece of legislation. And hopefully when we convene our session in 2008, we will come back with the final draft of the bill.
Would you, this committee, I think, favorably reported this bill out last session.
Yes, Mr. Chairman.
And could you just highlight for us one more time the changes that have been made since last session to now, understanding, of course, that you got a little bit more work to do on it?
Yes, the changes from last session on this bill here and before you today, we are attempting to regulate it to only those permanent cosmetic technicians that are trained and certified to perform this much needed service. we don't want to open it up to all tattoo artists, and that's where the debate and the negotiation is taking place right at this point.
Okay, thank you. Questions of the author from members of the committee? Any questions? You're going to go back and bring us yet another version than prior to or at the beginning of the session sometime.
Yes, Mr. Chairman.
Okay. All right. Last call for questions of Representative Everson on House Bill 92. Thank you, Representative.
Thank you, Mr. Chairman.
The chair failed to recognize our, I guess, the judge of the day. The only judge I see in the room, Judge, we got two judges. Okay. All right. We got Judge McGarity from Henry County here to keep an eye on Representative Lunsford, I hope. And Judge Lawton. All right. I'm glad somebody's doing that. And Judge Lawton Stevens from Clark County. Good to have both of you with us. I want to recognize now, do we have a number, Representative Benefield, on your bill yet?
We have an LC number.
And we'll do it by LC number.
A resolution and a bill.
Okay.
And I don't have the copy. Yeah, the copies are in the packet. LC 293004 is the bill. LC 293006 is the resolution.
One of the reasons for this meeting today was to hear the results and a report from Representative Benfield on the work of her Eyewitness ID Study Committee. I have thanked her privately, and I will do so publicly, for a lot of hard work on this issue over the interim. Although I'm just now seeing it for the first time today, I think it will be helpful for the committee to hear a little bit about the work of the study committee, what went into the study committee, and what the result and product is. So I want to recognize Representative Benfield, and she has Amy Maxwell with her from the Innocence. Are you with Innocence Project? Okay, from the Innocence Project. Representative Benfield.
Thank you, Mr. Chairman. We had a excellent study committee. There are a couple of members here this morning, Representative Mangum and Representative Setzer. We also had Representative Shipp, Mumford, and Hatfield. So it was an excellent committee. We had 5 hearings. We had wonderful witnesses. We had 2 of the top experts in the country on eyewitness identification testify before us. We had Dr. Roy Malpass from Texas, and we also had Dr. Gary Wells from Iowa, and they're the leading experts really in the world on eyewitness identification. They testified. We also had Barry Scheck, who I'm sure many of you are familiar with from the OJ trial. It was personally a thrill for some of us in the committee to be able to cross-examine and question the famous Barry Scheck from the OJ trial. So we enjoyed that, and he gave us all autographed copies of his book afterwards. I won't bribe the committee, but I could say, if we get a favorable response, we might consider getting some more autographed books from Barry Scheck. But that we really had a wonderful committee. It was substantive. We had input from all the interested parties. The prosecutors presented. Police made a presentation. Sheriffs, defense attorneys. Pretty much, we heard from judges. Anyone who requested to make a presentation to our committee made a presentation. We heard from some law enforcement officers in other states who have, within their jurisdictions, implemented eyewitness reforms. We heard from the head of the North Carolina Commission on Eyewitness Reform and heard firsthand how they've enacted their changes. So we just had some wonderful testimony. And I'm very happy to say, I'm crossing my fingers and holding my breath, that nothing has changed in the past few minutes. But we have a bill and a resolution that all the interested parties are supportive of. And I know they're here today, so you can hear from them so I don't want to speak for the other parties, but I think we do have buy-in from everyone. And I'll just run through quickly what we're proposing. The compromise is that, and as some of y'all may recall, because this bill has come before this committee twice now in the past couple sessions, there was a lot of controversy about putting specific eyewitness identification procedures in the code. And so what we have done is a lot of the reform measures we've put in the form of a resolution. And we all know resolution is not binding, but it does lay out what many of the experts who we heard from have testified to are the the uniformly accepted best practices. Most of this language is modeled after the National Institute of Justice, their recommendations. Some of this is verbatim. We have a lot of whereases just so that the good work of the study committee is put in there. But I can just go over the main points that I think everyone can agree on is a neutral administrator. And the language we put in here is that a neutral administrator is strongly encouraged, because we heard from law enforcement with some valid concerns that, particularly in small jurisdictions, they don't have the staff to bring in a neutral independent administrator. And there were also maybe times when a witness is available and they need to do the lineup right away, and they don't have time to bring in someone else. So we just put in the language that is strongly encouraged. And I'm looking at the top of page 2 of the resolution, subsection 2. That's where you find the strongly encouraged language. We also included some alternative methods that we encourage if a neutral administrator is not available. There's some wonderful automated computer programs. We heard from North Carolina. They're implementing these programs, and it's just amazing if we can get the technology, especially in some of the rural areas where they may not have the staff. I know funding is always an issue, but these computer programs, they do all they shuffle the photographs, they present them to the witness, and it makes it very easy on law enforcement to do a lineup with these computer programs. There's another procedure that's standardly accepted, which is using folders. And again, the administrator doesn't have to actually see what pictures the witness is looking at. So that's a way of dealing with lack of a neutral independent administrator. So we put those methods in. Another area of controversy was simultaneous versus sequential lineups. Some of y'all may recall sequential is exactly what it says. The witness would look at either a photograph or a physical person one by one. They would look at the suspects one by one, as opposed to simultaneous when you see all the photographs at one time. The problems that we've heard about simultaneous, and we heard testimony from Gary Wells, who invented simultaneous. That was his project and his proposal. With simultaneous, the argument goes that the witness is comparing one photograph to the next at the same time, as opposed to sequential when you compare the photo in front of you with your memory. And according to that logic, when you're comparing to your memory sequentially, the outcome is going to be more reliable. Now, that has been disputed, and we heard from Dr. Roy Malpass, who disputed some of those findings. So that's why we address the simultaneous issue exactly the way the Department of Justice addressed it, which is you could use either method. I do have one change to this subsection. All the testimony, I think this is agreed by everyone, is when you do use simultaneous, if law enforcement chooses to use simultaneous, it must be a neutral independent administrator. And I can get some language to that effect. But those two need to go hand in hand. Another significant measure we put in here is that the witnesses shall be instructed. They shall be given basic instructions before they view a lineup, and also that the outcome of the procedure is preserved. Any statements the witness makes specifically as to their level of confidence in the identification. Preferably, I'd like to see something recorded, but we understand there's maybe limitations. And also we heard from some law enforcement who testified that recording, video recording especially, could intimidate a witness. So we did leave it open that the recording could be in writing or audio or video. So we tried to take into account all the testimony we heard, especially from law enforcement, as far as the resolution. I'm happy to entertain any questions about the resolution, or I can move forward to the bill. They kind of go hand in hand. Okay.
Does anybody have questions at this point? Just go ahead.
Okay, most of the recommendations from the bill came as a result of the hearing we had with Barry Scheck, Dr. Wells, and Dr. Malpass, and we really had the foremost experts in the room to talk to us about this, and these were the recommendations that they made. And we had a wonderful working session, I think it was 2 weeks ago, with all the key parties where we just sat around for about 3 hours and hashed out the terms of this. But what we're doing, two major things with the bill. One is we're asking that as of July 1st, 2011, all photographic and physical lineups in Georgia must be conducted by a trained law enforcement officer. And we base that date on the input we got from law enforcement that they need that much time to get up to speed. The training shall be done by post, and we have representatives here who can talk about that. Currently, the committee heard the training that law enforcement gets today is 30 minutes on eyewitness ID, approximately 30 minutes as part of their basic training. So we thought that needs to be increased and a lot more substantive. But we also recognize that a lot of the beginning cops, law enforcement officers, are not doing the lineups. We're looking more at investigators who are at a higher level. And so we included the training for the higher level officers. I do not think this is a problem for law enforcement in smaller communities, and this is based on what I heard back from sheriffs and police, because in a lot of the smaller agencies, they'll bring in the GBI or they'll bring in another jurisdiction that's close by. So I don't think it presents a problem. We did not include show-ups for the trained officers because often a show-up has to be done immediately, and there may not be time to get a trained officer in to do the show-ups. So the trained officer requirement is only for the photographic and the live lineups. The other change we had is that we're requiring all law enforcement agencies to have written procedures about eyewitness identification. And we gave law enforcement the flexibility to draft their own procedures. Or if they so choose, they can adopt a procedure that's already in existence. There's lots of model procedures out there. So they don't have to reinvent the wheel. We came up with 2009 based on input from law enforcement that's a reasonable time frame for them to get procedures together. And the procedures could be as simple as our agency does not conduct eyewitness IDs, because we did hear that there are agencies that don't conduct eyewitness IDs. So we're certainly not forcing small police agency to come up with procedures, that this is not something that they do. And we heard from the Innocence Project, they conducted a statewide survey, and we learned, it was at 80%? Somewhere around 80% of Georgia's law enforcement agencies do not have written procedures for eyewitness identification. So we saw that as a major problem, and law enforcement agreed with us on that. And the police chiefs have been wonderful and being very proactive on this. They've already come up with some model procedures that they're distributing to their agencies. So they're giving them a model procedure already. So this should be, I'm hoping, fairly simple for a lot of the agencies just to adopt the model protocol that's in existence. So I think I've covered the main points. I want to have Amy Maxwell set up here because she has been so helpful throughout the process. She's the one who originally brought the bill to me. And I'm sure many of you heard about the most recent exoneree. This makes number 7 in Georgia. Every person in Georgia who was wrongfully convicted and exonerated through DNA testing was convicted based on eyewitness identification. We've heard from just about every single exoneree. Almost every, I think there were just the 2 in Savannah did not come. And we heard from Mr. White. He chose 2 days after he was released from prison after serving 12 and a half years for a crime he didn't commit. He came to our committee hearing, and I told him that was one of the last places I would come after if I'd been wrongfully convicted. But it was wonderful for him to address the committee. And the stunning thing about his case, if y'all have heard, you may have already heard about this in the media, and here's the lineup in his case. The actual rapist was in the original lineup, and the victim identified Mr. White. They identified the wrong person. So that's a glaring example of how eyewitness testimony is fallible and faulty in quite a few cases, and certainly every case in Georgia. So with that, I will welcome questions, or if the committee wants to hear from I know there's lots of other people in the audience who've worked with us on this.
We do want to hear from Amy, but this board is lit up with
Okay.
questions. So I'm going to hear from the committee members
And Amy
first.
I may need her assistance with the questions.
Sure. I think the first request was from Representative Bearden.
Just a quick question on page 2, line 24 through 26 on the bill.
Diane, can we get another copy for Amy?
This is also the first time I've had a chance to read over the bill, but we're talking about withholding funding for state funding and federal funding. Is there an audit process in place, or are they supposed to send their program? Excuse me while we...
Only because it's the holiday season, I will I not admonish you, Representative Mangum.
We're getting our groove back.
Continue, Representative Bearden.
Just didn't sound like Hank Williams on the way in. I was listening to this morning, but on this right here, we're talking about withholding funding. Is there something, an audit that's got to take place, or they send in their procedure to a state agency to make sure they got one listed, or what, anytime we start talking about withholding funding?
And thank you for raising that. I neglected to bring to the committee's attention, we do have a sanction there. This is based on existing law. Some of you may recall Senator Mitch Seabaugh had a bill, well, it's now law, several years ago that dealt with high-speed police chases, and this was the sanction that he put in the code. So we base this verbatim on existing law. So I'm assuming there's a process in place, but I do not know that. So I don't know if there's someone in the room
So
who knows
basically, if it's
that.
asked for, it needs to be delivered.
I'm sorry?
So basically, if it's asked for by someone for the courts, then they would just produce the SOP that they go by and give it to the whoever asked for it, or the subpoena that's asking for that information.
I don't know. I don't know the specifics.
Is that correct?
If somebody
Okay.
in the room knows it,
Mary-
that'd
Mary
be great.
Beth,
If not, I can get the
I hate to
information and
put
come
you on the
back.
spot.
I'm on the Criminal Justice Coordinating Council, and I can say that when you apply, there are a list of certain provisions you have to make assurances that you have things in place. If this were the federal funding that comes from them, you have to make some sort of, you could require that they make some sort of assurance that this type of policy is in place.
Thank you.
Okay. Does that answer your question?
Yes, sir.
The chair's going to try to do this in the order that the light started flashing. I think the next one is Representative or Chairman Franklin.
Thank you, Mr. Chairman. I had a couple of questions, if I could. And the first one, while it's fresh on my mind, relates to the newspaper photograph that you held up. And I was just curious as to whether or not the actual guilty person was a filler or was a suspect.
He was a filler.
Was a
He
filler.
happened to be in the jail on unrelated charges, and it was a total fluke that he even appeared in the lineup. The way they found him is thanks to I know John Bankhead's here with the GBI. The GBI found that they did a search, and they found a cold hit on the actual perpetrator. I think it's Mr. Parham. Yeah, James Parham, and he is now in custody. But it was a fluke that he was even in the lineup.
Wow.
He actually did not fit, the actual perpetrator did not fit the description given by the victim. She described a slender man as her rapist. And if you'll notice in the photo, all the suspects are slender except for the actual rapist.
Wow. Okay.
So that shows how flawed eyewitness testimony is.
Yes, it does. Thank you, and thank Mr. White Bankhead for that great work on that.
And they are terribly underfunded. Let me make sure that we heard extensive testimony about that.
Great. But the main reason I pushed my button was the section 17-4-70, which starts on page 2, line 31, and it gets really into the my concern is the last sentence, which is over at the top of page 3. The failure to have such trained peace officers conduct a photographic lineup or physical lineup shall not, in and of itself, preclude testimony and evidence related to witness identification. being admissible into evidence, that matter shall be in the sole discretion of the court. And two concerns would be if we don't set out a certain guideline and one jurisdiction is able to do one thing and another is able to do another, couldn't the whole thing be struck down because we're not really providing equal protection? We don't have something uniform statewide. Wouldn't we need something uniform?
I think we're going to see a uniform policy. I mean, the police chiefs have put out model protocol, and I think we're going to see the majority of law enforcement agencies adopting those. That was one of the points behind the resolution, was to lay out what we think the generally accepted standard best practices are. All the models that we've looked at, and we've looked at a lot of states and a lot of individual law enforcement jurisdictions have adopted model protocol for eyewitness procedures, and they're all essentially the same with a few minor tweaks and nothing that I would consider significant enough to throw the whole thing out. As I mentioned in my main presentation, the big discrepancies you see are neutral independent administrator, whether that should be mandated or encouraged. And I think pretty much everyone agrees it should be encouraged whenever possible. If a neutral administrator is available, he or she should be used. And then the other area of controversy is the simultaneous versus sequential. But again, this language is standard and accepted. And I think we're going to see most agencies adopt this. I'm glad you brought that clause up, though, because I forgot to put to the committee on page 3, line 5, the prosecuting attorney's counsel has asked that last phrase after the semicolon, that matter shall be in the sole discretion of the court. They've asked that be struck, and I have no opposition to that. And I meant to present that to the committee. In the spirit of working with prosecutors, we're in agreement on striking that.
Well, that even if you strike it, it would still, where would the discretion be if the code section says that doesn't in and of itself preclude the admissibility of the evidence? So you're really leaving it to the discretion of the court whether you use that language or not. And that's another, was my final concern, Mr. Chairman, and then I can now be quiet, is shouldn't we make it as clear-cut as possible as to what our intent is rather than leaving discretion to the court?
Well, the resolution is intended to put forth what the legislative intent is, what standards we would like to see. Now, I did have a bill that put all of this in the code. There was very strong opposition from the prosecuting attorney's counsel, and if you recall, we had that bill before the committee. It passed this committee unanimously and then was killed in rules. And my concern, which I think is valid, is that the same fate would meet the bill if we put all of this into the code. The language here was put into allay concerns by the prosecutors that this evidence, if it did not follow the resolution, that eyewitness testimony would be excluded. So we wanted to make it clear that in and of itself shall not exclude the testimony. It's up to the court, and that's what's being done currently.
But this one,
that's what's happening right now.
But isn't this one that the requirement that it be done by a trained peace officer by July 1 of 2011, so that if say in August 1, 2011, a photo lineup is done by someone who's not a certified peace officer, we're saying that in and of itself doesn't preclude that testimony.
That's right.
And
the parties can argue it to the court.
That was basically the point I was making. Is I think we should probably need to tell them what is admissible and what isn't by the law. But that was my
okay. If you can help me get it out of rules.
Thank you.
I can just say we've worked very hard on getting this language just where we've got buy-in from all the parties, but I'm happy to entertain any suggested language you have, and we can continue the discussion on that. I can say there was a significant discussion about the admissibility. I will also say the study committee has not had a chance because they weren't all at the last hearing for various valid reasons. So the committee has not approved this. either one of these bills. I've circulated it to them all by email, and I have not heard any objections, but it has not been formally voted on by the study committee.
And I wanted to thank you for the hard work, as Chairman Rawson did, because it is vital that as a state, that as we seek to do our job of justice, that we don't wrongfully convict an innocent person, because we actually do want to convict the guilty. And I thank you for that hard work.
Thank you. And I will say, talking about not letting the real perpetrator, the real offender go free, in the most recent case, Mr. White being wrongfully convicted, the actual perpetrator did go on to commit another rape. So that's what happens when you get the wrong person.
Okay. Thank you, Chairman Franklin. Representative Setzler, to be followed by Representative Levitas.
Thank you, Mr. Chairman. I was going to address Representative Benfield on the bill, but I did want to speak to Representative Franklin's question directly. As we listened to the hearing and the testimony in the study committee, it was a real concern of a number of ours that whatever framework we moved forward, there not be an increased opportunity for procedural trip-ups by well-meaning law enforcement officers that substantially met requirements, but that for some technicality allowed the eyewitness piece to be thrown out of court altogether. And that is a key component to many of these trials. And we didn't want to throw procedural roadblocks in place that allowed that to happen where justice wouldn't be served. So I would submit to you that what this, as Representative Benfield's laid out, this was a carefully thought through structure whereby it's codified. It's very clear for law enforcement agencies they've got to accomplish certain things by a certain date, but wouldn't in and of itself allow something good eyewitness testimony to be thrown out by a technicality just because someone hadn't gone through this training if they had otherwise gone through a very disciplined process of eyewitness ID. So I think that was a careful balance he struck. And it was with that note that I wanted to just kind of wrap up and say I want to give my thanks to Representative Benfield as a member of the committee. What we see here, in my opinion, is something we rarely see in the legislature. This, in my opinion, is a leadership move more than it is an act of legislative activism. So often we see, as legislators, we see what right looks like, or we think we know what right looks like, and want to codify it in a detailed, very prescriptive law. We've seen other states do that. North Carolina came and spoke to us early on in the process and took what's in this resolution, which is a best practices, and codified it and said, thou shalt do this. And if you don't do any of these things, then the eyewitness ID is subject to be thrown out. I think what Representative Benfield's done here, and this is what I would like to commend her for is leading the committee, is she's started a process where the law enforcement training centers, the law enforcement agencies have really taken this issue as a front and center issue. They're deciding for themselves what works best for their very diverse departments. And they're going to put something in place, but it doesn't lock them into a very narrow band of what they shall put in place as designated by us as legislators. And I think that's a key thing to take out of this. I think last session folks were criticizing this approach in that it was too prescriptive. I think it's refreshing what's been done here, and I think we're already starting to see the impact of that across the state. So I'd like to commend Representative Benford.
Thank you. Representative Setzer attended all but the last committee hearing, so he was a great addition to the committee. I will say Barry Scheck was the one who, in his presentation, testified that we should just ask that all law enforcement agencies adopt their own policies. He was very clear that he didn't want us to put into the code a lot of the detailed best practices, that he thought that law enforcement should take ownership of their own protocol. So I thought it was interesting that it was Barry Scheck who was the person who gave me the idea for this, and law enforcement, they were all nodding their heads in agreement when he testified to that.
Excellent. Representative Levitas and then Representative Everson.
Thank you, Mr. Chairman. And at the risk of piling on, I too want to commend Representative Benfield. I think this is one of those rare kumbaya moments between the defense bar and the prosecution where everybody ought to be on the same page. And I know this has been a passion of yours, and I think it really does help us get, as Representative Franklin said, Chairman Franklin, to meet justice. So I absolutely commend you. My only question is very technical in nature, which is on page 2 at line 10, the first few words of subsection B, which says that prior to July 1st, 2008. And my only question is, if the bill isn't signed by that time, is that a technical problem if the bill winds up being signed after July 1, 2008?
It won't be signed after. It's got to be signed within 40 days. Well, I guess the legislature
It
could
depends
go on.
Right.
I was
Let's
going
hope
to
we're
ask
in
Representative
recess.
Levitas if he knew something about scheduling that session that I
Just
didn't.
having observed the last couple of sessions, you never know.
Unless I'm backtracking 40 days from July 1st, we would have to be going into session until mid-May.
Let's not even think.
Let's
about
hope
that.
that's not going to happen. And we have post here, and they can. Butch Beach is here. He said that they might have these in place as early as February 2008.
And that was going to be my question. I assume this was something they're already working on.
They're
Wouldn't
working
have
on
any
it.
Problems, so okay.
I think it's going to be in place well beforehand, and they have been wonderful. They've been at all our hearings. We've had extensive back and forth discussions about the funding issue, and we were even prepared to get private donors to help with the funding, so to make sure that they had the money they needed to do the training, and then they were able to find they said that they would have adequate funds within their existing revenue stream. So Post has been, and public safety training, they have been wonderful throughout this process.
Thank you, Mr. Chairman, and thank you again, Representative Benfield.
Thanks.
Representative Everson.
Mr. Chairman, I waive. My question was answered in the previous questions.
Thank you. Any other questions from members of the committee? You want to take a few minutes and let us hear from Amy?
Yes, I would. But
No.
Amy has
You've
worked
done
so
good
hard
work.
on this. I would love to hear from her. She's been extremely helpful.
This is not under public testimony. This is assisting the author.
Well, I just want to thank Representative Benfield and the entire committee. I, as a Georgian, am extremely proud of the Georgia legislature. Everyone took this issue very, very seriously. The legislators listened very carefully, asked wonderful questions, and really encouraged all the parties to come together and come up with this plan. I think I actually was among the folks horrified when I finally pulled out the file and realized that the real perpetrator was in the lineup, and it's very difficult to go back and explain why that happened, except that all the things just lined up for that to be the way it was. I wish also that I could tell you that I planned this timing, because then I would be a strategic genius, but I am not. That just all happened to coincide, but I think it really does emphasize the need for giving law enforcement the tools to do their jobs even better than they already do. Thank you.
We did have every major media outlet at our last study committee hearing, and it was because Mr. White had just gotten out of prison and was here to testify. Thank you.
Last call for questions on eyewitness ID.
Do you want to recognize some of the other folks or not?
Yeah, you got one question from a member, so let's be sure that the members get their questions answered today. Chairman Franklin.
Yeah,
I could tell it was you.
I apologize. I just thinking back on the ones who have been exonerated based on faulty eyewitness testimony. I'm reminded. Was there any corroborating? Easy for me to say it. Testimony that identified that person as the guilty party in those cases, and wouldn't it, if so, or if there wasn't, rather, would it be good to put in legislation that it would require two witnesses to the same act, at least two corroborating witnesses?
I think that would throw the whole compromise into an absolute tailspin. Although I wish that I think good prosecutors, I'm certainly not going to speak for them, but I think good prosecutors recognize that eyewitness identification, along with confessions, are the two most prone to error types of evidence you can have in a criminal case. And in those types of cases, they will do everything they can, in law enforcement as well, to get other evidence. And certainly to have more than one eyewitness is critical, but not every case. In fact, most rape cases, or a lot of rape cases, I'm no expert, but you don't have an eyewitness. I mean, additional eyewitnesses other than the victim.
I'm not saying two eyewitnesses, but
other
at least
corroborating.
two witnesses, which could be physical evidence or something like that, but where you don't just have or don't just allow, if the only thing you have is one eyewitness, that would not be sufficient.
Again, I think that I don't know anecdotally any specific case, but I think there probably are examples of cases where eyewitness ID is the only evidence. I think in most of those cases, it's not going to even pass grand jury muster because it is so faulty, and eyewitness identification is recognized as being faulty. Amy could speak better to the 7 exonerees in Georgia. I'm trying to think if there are some that have other corroborating evidence. I know Clarence Harrison, I think there were a couple of folks who said they saw someone fitting his description, but I think the actual eyewitness ID was just one person.
But, for instance, in Mr. White's case, they did a hair analysis, and the hairs look sufficiently similar. Although, of course, we know now that's not actual science, but there are other little pieces and some circumstantial evidence that lead to these guys. Right.
Calvin Johnson, they had blood type, which put him in a pool of, like 1 million other people. So it really wasn't a great excluding factor, but they did have blood type. So a lot of these cases are 20, 30 years old, so you're looking at evidence that's not as well accepted today. But I can't think of a case where there was something like a fingerprint or some other really strong piece of evidence. Every case in Georgia of wrongful conviction was based primarily and in large part on eyewitness ID.
Thank you.
The other reason for the meeting today prior to the session is for us to test drive our new microphone system in here. So y'all are doing quite well, too, better than I am. Representative Mangum and then Representative Abdul Salam.
Thank you, Mr. Chairman. Representative so already said it, but I just want to ditto and say thanks to a woman who really was a driving whip to get committee persons there to meetings, and a lot of really hard work went into this bill. And it is a deeper problem as you get into it. I did not realize even myself as the problem is as severe as it is. And I want to thank you even, Mr. Chairman, and the leadership of the House, because this is revolutionary the way we did this legislation. It's something that needs to be noted. So often we have, if you're in power, you just run something down the throat, or it may be totally against everyone's interest. But I really do, and not just to say about whether or not Democrats in power or Republicans in power, I just really want to applaud leadership on this, because it really was leadership. And the vested interest from both sides and all sides came into this process and came up with something, including but not limited to going around the country to get the best practices and bringing in the experts and coming up with something that I think will have a tremendous difference in the lives of Georgians. And it is interesting when you do look at someone like a Calvin Johnson, who sits in jail, the prime years of his life, and the perpetrator is never even apprehended because they never even were looking they were never looking. And even with the number 7, someone goes and commits other crimes because we did not have the right guy, and we rested on, okay, this is it. And it really is astounding to me that even one of the victims of the crime to this day continue to say that, yeah, he is the one that did it. I don't care what DNA says. He's the one that did the crime. And so the reliability of our witness has been an eye-opener for me personally. And I want to, again, just thank the chairperson of the subcommittee, the chairperson of this committee, and the leadership of this General Assembly for taking this type of approach, because it was a situation where one of the rare moments where we can say that all the parties had an interest in the process to move Georgia forward from some severe injustices. And we've seen some injustices across the country, and we don't want Georgia to be known as one of those places where find the injustices that have existed. So thank you so much, and thank the General Assembly. Thank you.
Thank you.
Madam Chairman.
Thank you, Representative Mangum, and your point that builds on Representative Setzler's point, I think, is well taken. This is the way the process ought to work. To identify a problem and work in a bipartisan manner to come up with some solutions, and that, I think, that's what's most satisfying to me as a member of this House. And and I appreciate Representative Benfield and all of the members of the committee for doing that. Representative Abdul Salam.
Thank you, Mr. Chairman. To add to my gratitude and thanks for the phenomenal work that's been done on this project, my question too goes back to the case of Calvin Johnson, having been in Clayton County at the time.
Mm-hmm.
I'm wondering, maybe Amy might be able to speak to it. It said from the onset that one victim identified him and another victim did not.
Yeah.
So if you came up with a situation like that, who determines what weight goes to the witness ID? And then the second part of that was that, is there any standards being talked about in terms of if you're using a photo lineup, using most current photos? Because in his case, again, they used a 20-year-old photograph, but at the time of the rapes, he had a full beard and was gruffy and stuff, and they used the clean-cut photograph. So is there any discussion as to the standards of the weight if there's more than one witness and they conflict each other? Then how is that weighed? And if they're using photo lineups, or is it something that will say you've got to use a current depiction of what that person looks like? Those are my two concerns.
I'll let Amy address Calvin Johnson's case because she's more familiar with the facts, but I'm sure since you're familiar with the case, he had two trials, one in Fulton, one in Clayton. He was actually found not guilty of the Fulton charge, so it's really fascinating. But Amy can speak specifically to his, and then I'll talk about the photo issue.
Well, I think Representative Benfield answered that question because the witness that identified him, he was convicted in Clayton County. The Fulton County witness did not identify him. He was not convicted in Fulton County. And I think that if you have two witnesses, one who can identify, one who cannot, it's really going to be up to the law enforcement first, then the prosecutors, and then the jury. I don't know that can be written in as to how you balance that because it's all individual with the case, the investigation of the case.
The photo lineup we have, if you'll look on the resolution, starting on page 2 at the very bottom, subsection 8, we go into best practices on the photos, and all of that is based, I think that's verbatim from the National Department of Justice, the recommendations that they made under the supervision of the Attorney General's office. And the GBI, John Bankhead, I saw him in the hallway. Yes, I don't want to put him on the spot, but I did ask him if he could, if not today, perhaps during the session, give an update to the committee because this is really important for all crimes on their photo database because a lot of law enforcement agencies rely on the GBI's database, and that is a significant problem. I know Representative Bearden's probably familiar with that, being a police officer on the front lines, that having access to a good quality base of photographs for these lineups is critical because if you've got some very specific, someone who's got a tattoo on their left side of their face, trying to find 4 fillers that fit that description could be difficult for a lot of law enforcement agencies. So it's critical that the GBI, did I mention they're underfunded? The GBI be funded to have a good database, and also, I mean, this is a completely different issue, but the GBI does the DNA, they run the DNA test. There are hundreds and hundreds of rape test kits all over the state that have not been tested. That have not been because of lack of funding. It's not any fault, in my opinion, on law enforcement. It's just lack of funding. So we saw a lot of problems through the work of the committee.
You were doing so well till you got into money. Any further questions from members of the committee? If not, I'll be happy if you want to spend about another 10 minutes if you want to recognize a couple of the people that you think it would be helpful for us to hear from today. I'm happy to do that.
Thank you. And I'll just thank the people who worked really closely with us on this, and I think they're all here, so if any of them want, I don't want to put them on the spot, but if any of them want to speak, I'd welcome their input. Certainly Amy Maxwell with the Innocence Project, Frank Rotundo with the Georgia Chiefs of Police Association.
I saw Frank here.
Terry Norris and Oliver Hunter, my apologies. Oliver Hunter with the Sheriff's Association, Rick Malone, and we all know Christy Lyncham because she worked with this committee, with the Prosecuting Attorneys Council, and Chuck Olson came to some of our hearings as well. John Bankhead with the Georgia Bureau of Investigation, and also Mark Williams with the GBI. Am I getting his name right? Okay, but our work session, Mark Jackson, thank you. Mark Jackson came to our working session and was very helpful. With the Georgia Association of Criminal Defense Attorneys, Sandra Michaels, Jack Martin came to a lot of the hearings, and then we also have Don Samuel representing them here today. Sarah Tatanchi with the Southern Center for Human Rights. Did I miss? Oh, of course. Public Safety, the Training Council, Butch Beach, their executive director, was extremely helpful throughout the process. And Ron Jason, a former magistrate judge, testified from the judicial perspective. I think I've covered every. So if any of those folks want to address the committee,
thank you
that
very
would be great.
much.
Specifically the database, if you can.
John, do you want to be heard
if
on
not
that?
today, some other time.
I'll mention this, and really nothing has changed. As part of the Georgia Crime Information Center's upgrading the criminal history database, they're looking at expanding the capability into having a photo lineup capability. In pursuing this, they're looking at Virginia's setup, and as it stands now, they're going to have to get a request for proposal, in other words, a bidding process for companies that specialize in this type of software to integrate it with the criminal history database. And they're looking at, as far as a time frame, somewhere towards the end of 2008, possibly 2009, to have this up and running. To where now there are certain agencies that now that have this capability, but what we're trying to do is expand that photo database where if you do have a lineup situation with a photo, you can extract from that database a series of photographs that would be similar to the person in question. I'm using the example of a bald-headed guy with glasses, so to speak. It's that type of capability. It's very specific as far as being able to keep the person similar to the suspect you're looking at.
Okay.
But it's a federally funded proposition with respect and connected to the upgrading the criminal history database.
And you're also revising your eyewitness identification procedures.
Yes.
So that's been an excellent change.
Thank you, Mr. Bankhead. Final call questions from the committee. Well, I wish we could vote today. You've done a
the study
great
committee
job.
hasn't formally approved it yet either.
So let us know when you get that, and I understand there may be a tweak or two yet to come.
Just that one phrase
Okay.
that I mentioned. I'm not aware of any other changes. at this
You've done
point.
excellent work, you and the members of the study committee, and I applaud you.
Thank you.
Again. And it's the chair's intent to take this up fairly early in the
Good.
session. So thank you very much again.
Thank you.
Maybe. Chair yields for the next part of the program or agenda to Secretary Bearden.
Next bill on the agenda will be House Bill 908 by Chairman Ralston. It's in reference to the House Bill 1059 we passed 2 years ago. So I'll just turn it over to the chairman and let him talk about the bill.
Thank you, Mr. Chairman. Last week, I, along with other members of this House, including Majority Leader Keene, pre-filed what is now House Bill 908. That bill was filed in response to a decision handed down, I think, the day before Thanksgiving by the Georgia Supreme Court in the case of Mann versus Georgia Department of Corrections. In the Mann case, the Supreme Court found a problem with a portion of the residency restrictions in it actually wasn't House Bill 1059, but it was Senate Bill, Mary Beth, do you remember the number 221 by Senator Edelman from back in the 01 or 02 session, and I may have those years wrong. It was incorporated and carried forward, obviously, in the sex offender legislation that this House approved in the 05 session in terms of restrictions on residency for certain individuals. The Supreme Court's problem, I think, with the bill was that there was no exception made in the original legislation for those offenders subject to the restrictions who complied with the law and moved to a location, purchased a home, and then one of the facilities such as that are designated here, a child care facility, church, school, or other areas where minors congregate, came in after the fact. And it was their opinion that that ran afoul of the takings clause in the Constitution. The effect of that decision has been to vacate all the residency restrictions now in Georgia. At the present time, there are none. We felt that it was important to respond to that decision, addressing the concerns of the Supreme Court, so that we can get this matter resolved quickly. I guess it's a little bit of an irony in that after Georgia acted in 05, many other states used what we did as a model. And now every state around us, with the exception of one, has residency restrictions. And now we have none. So it's our intent is to move on this rather quickly when the session begins, and we'll certainly have public testimony and comment as we begin the session. The bill's actually fairly simple, and I'll go through the bill with you in terms of what it does. To be consistent in terms of measuring the distance, House Bill 1059 or Senator Edelman's bill, I can't now remember which, basically provided that for employment purposes you measured from the outer boundary of the property, but did not have that same language for residency purposes. So this includes that in a number of places, beginning on page 1, line 22, to make it consistent. The measurement would be from the outer boundary of the child care facility, school, or church. It also adds in a couple, 3 places, beginning on page 2, line 1, a prohibition not only against employment, but a prohibition against being a volunteer at these places. Then it begins, the real meat of the section begins on page 2 on line 17 by basically giving a carve-out, as it were, or an exemption to those individuals who either own property or are employed prior to the child care facility, church, or school locating within the 1,000 feet. Those persons, it's sort of what some states refer to as a move to the offender exception. And those persons would not be guilty of violating the law if they were there first. And it goes on to provide, beginning on page 2, on line 31, a couple of ways on both instances that the individual could provide proof of ownership or proof of employment to the sheriff in the county where there was some question raised about whether or not they were there first. So in effect, I think the bill does a good job of addressing the concerns by the Supreme Court. We've gotten a lot of input. Legislative Council has been extremely helpful. Our aide, Sally Fox, has done great work, and I want to thank Mary Beth Westmoreland and the folks in the Attorney General's office for all of the input they provided, because I think this reinstates the residency restrictions but does it in a way that is consistent with what the Supreme Court had problems with in the Mann decision. So with that, Mr. Chairman, I'll be happy to try to answer any questions, and if I can't, then I know a couple of three people maybe that can help me.
Okay, Representative Franklin.
Thank you, Mr. Chairman. Couple of questions. I do thank you for bringing this forward because we need to get these residency restrictions back and protect our children. Two questions, and maybe you could clarify. The first one is, without mentioning a specific effective date, this would take place on July 1st, would have an effective date of July 1st. Would we not be protecting our children better by having it on signature of the governor?
Well, we've had a lot of discussion, and I'm not sure that issue's been resolved. We would, I wish we could make it retroactive. I'm not sure that we can.
Definitely can't do that.
But obviously what our intent is to, hopefully, this committee will look favorably upon this measure, as well as the full House and the other chamber across the hall, so that we can get this to the governor's desk quickly.
I would urge, if there's any way to make it to in any redrafting, that we make it effective on the governor's signature to protect those children between that time and July 1st. The other one is, and this might just be a style point, but I would hate to see yet another challenge because of contradictory language, because I have seen in other legislation where we use language except as provided in subsection so-and-so, and where what we're going after is subsection C, as you said, starting on line 17 of page 2, subsection E. Would we be protecting ourselves from any future challenge if we start subsection B with except as provided in subsection E of this code section, no individual shall reside, and we do that on for B, C, and D, just to make sure that there's no contradiction in the code section?
I'm not sure that there is a contradiction, Chairman Franklin. I'm happy to think further about that as we go forward. Jill, do you have any, I don't want to put you on the spot, but do you have any comment as to whether that terminology should be there as opposed to the way it's presently drafted?
For sure it's not applicable to D because D is the loitering provision.
Right.
We're not addressing it. But I think I'm following your thought is that I'm not sure that it's necessary. It's not really a contradiction.
Yeah, I'm happy to continue to think about that between now and
I was just thinking if there's any way that someone would find a loophole to keep from having this thing be enforced yet again.
Well,
I wouldn't want to give it to them if we could.
If I can respond to that, and I appreciate your comment about anticipating what could be problems. That's why we have the employment provision in here. The employment provision was not specifically addressed by the court in Mann, but there was some language in the decision, I think we all agreed, that expressed some concerns possibly about that, and so that's why we wanted to go ahead and deal with that also.
Thank you.
Representative Abrams.
I have a few questions. Mr. Chairman, can you speak to any comments that the authors have had about the vagueness of where minors congregate? that language is repeated several times in the document. And my concern is that it's so vague as to cover a host of issues such as malls, parks, any place that suddenly becomes popular because kids decide they like it, and how we intend to enforce against language like that.
Well, that was in 1059, if you'll recall, and I think we're carrying that language forward. I don't know, Jill. I'm not aware of any challenges to the law on that ground. I'm not sure. I don't know if you are.
It's actually a defined term now. It used to be broader.
Okay.
But it is now, it's defined in 42-1-12, which is definition for the chapter.
Mm-hmm.
Or article, I don't recall what we're in, article or chapter. And areas where minors congregate shall include all public and private parks, recreation facilities, playgrounds, stadiums, music centers, gymnasiums, school bus stops, and public and community swimming pools. So it's a finite list at this moment. Whether there's been challenges, I don't know. I'm sure the Southern Sun would be a bit answer that.
Okay. Second question I had, can you speak a little bit about subsection E2?
On page 2?
Yes. Lines 26 through 30.
That basically says that if you owned property and lived on the property or were employed at a place that would otherwise be prohibited, if you were there first and can prove that you were there first and you were there prior to the effective date of House Bill 1059, that you would not be prohibited from living or working there. I mean, that's kind of the heart of the bill.
Okay. And then my third question is, has there been any conversation about the level of crime, the issue of youthful offenders or those who've not, I mean, you know my...
Yeah, the short answer is yes. The longer answer is that there is a lot of debate about that. My view, and I'm here as the author of the bill, but I'm also now speaking as chairman, is this. My view is I would like for this bill to go forward without being caught up in that discussion. If someone has a bill that addresses that issue, then I'm happy to consider that, but I don't want our ability to reinstate the residency restrictions to get caught up in that. I think that's a very fair discussion. I think it's one that more appropriately ought to be part of a separate bill.
Okay, thank you.
Representative Setzler.
Mr. Chairman, I just want to ask some detailed questions that just deal with crafting and make sure we're not contradicting, or something's not being contradicted here. And if this is not the time and the place, I can certainly hold these questions till another time. Initially, I did have the question that Representative Abrams shared about the language, area where minors congregate, and that was a concern. I think it's been answered. I see as we walk through these sections, area where minors congregate is in most of these sections. And again, I'm within section 2, subsection B. It talks about residence, and it lists child care facility, church, school, and again on line 21, or areas where minors congregate. That's listed there with the requirements dealing with residing. Page 2, line 1, it talks about employment or volunteering. It's limited to child care facility, school, or church. It doesn't list areas where minors congregate. I wasn't sure if that was an intended omission or if that areas where minors congregate ought to be included in there as well. It is included in the other.
It actually is included if you look at line 7, 8, and 9. And there was a distinction that the committee made back in 2002 to distinguish purely somebody registering versus a creditor.
Okay.
And somebody policy decision at that time was that the registrant should have
Okay, so
The predator is subject to both 1 and 2, but the sexual offender is just subject to paragraph 1.
I think
and that essentially tracks 1059.
I think that was the heart of my question. So just to understand, a registrant can't work within 1,000 feet of a child care facility, school, or church, but a sexually dangerous predator wouldn't be able to be employed or volunteer at any place where minors congregate. And that's the public policy intent.
And also could not at a facility, a child care facility, school, or church.
Okay.
So the predator is covered by both 1 and 2.
Okay.
The offender is just covered by 1.
That was my question, Mr. Chairman.
Representative Salam.
Thank you. Thank you, Mr. Chairman. My question, I actually have a couple, but I guess the first one from Representative Setzler's question is what standards do we use to determine, is there a separate list for the sexually dangerous predator as opposed to the offender?
This bill doesn't change anything about the list at all. It simply adds volunteer. It simply clarifies how we measure the distance, and then it adds the carve out for those who are living by virtue of owning property or employed prior to the church, school, daycare facility moving into the area, moving in with 1,000 feet. Doesn't change anything about under current law about listings or anything of that sort.
Okay. Then my next question is, do we have any idea how many offenders, registered offenders, actually own property, and how long it would take to do all the measurements?
Do we have that information? I don't know about how many. Okay. Right. I know that, and I've never done this search, but I know that I have constituents that have done searches and can tell me in my house district which sexual offenders live where, because it's on the internet. I mean, it's required to be posted.
I understand, but it doesn't tell you whether they own their homes or not.
Well, because I don't think that under the current law or the law that existed prior to November of this year, there was a distinction made. This bill, if passed and signed into law, would make that distinction. So then if there were a question about whether they owned it, then they would have to satisfy law enforcement in the community.
I guess the heart of my question goes to how extensive will it be to implement this section in terms of finding out how many offenders are homeowners and then actually having somebody to do the measurements. How costly will that be? How long will it take? And then the next part of that is, will offenders be able to purchase homes in areas that don't currently have facilities as daycare centers and schools, but they may be projected to build them later? Will they be prohibited from purchasing a home in a subdivision that you know later on will build those amenities?
I think under this bill, the answer to your last question would be that they would be able to. In terms of the administrative aspect that you touched on in cost, I mean, I don't think it's any greater than it would be now. The burden here, if there is an issue raised, the burden is on the offender to prove to law enforcement or probation, as the case might be, I suppose, that he or she was there first, and, by producing the deed to their property, property tax bills, W-2 forms, that sort of thing.
Thank
you. And let's see, Representative Benefield, I believe, was next.
Thank you, Mr. Chairman. And I apologize if you've already addressed this, but I have more of a big picture concern, and it's the same concern I've had with the law when we originally passed it, and that is whether there's any proof, and so I want to know if you are aware of any studies showing that these residency restrictions actually reduce sex offenses against children? Because I know there's a lot of conflicting information out there. So are these residency restrictions really effective?
I don't know. I'm not familiar with any studies, and my first reaction would be that they are rather new, being about a year and a half that we've had it in place in Georgia, and other states probably not longer and of shorter. So I'm not aware of any data, except I can tell you that the people of Georgia, in my view, families applaud this because I have received a tremendous number of emails and phone calls from people who are very, very concerned about allowing these people to live wherever they choose. But as to any studies, I can't point you to any at this time. I'll check before the session begins.
I guess the only thing really to do is lock them up for life, and that would take care of that. I believe it's Representative Randall that was next.
Thank you, Mr. Chairman. My question addresses was actually probably to law enforcement to answer better. There were always questions about implementing this particular piece of legislation. I'd like to know, if any, if the new version of this will help or not change the problems that have evolved with law enforcement implementing the legislation.
You're the only one left in law enforcement. You want to address that?
We are the people, the sheriffs are the people that enforce this provision at the local level. And I don't see the revised residency language creating any more work. And I think that's what we're dealing with for the most part with this provision. At the appropriate time, we would talk with Arthur and the chairman about some other issues on how we think we can help the big picture, as you spoke, in terms of total implementation and be a little more effective from our position.
Well, my question arises because, of course, I've been in touch with my sheriff and the region in which I live, all of the sheriffs in that region, and I think if we're going to continue to revisit this, I think it would just make sense for us to try to fix all of it instead of piecemealing it together. I don't want to hold this up, the residency, because that's very, very important to not just us in this room, but of course those of our constituents that are in fear of not having any residency laws in place.
Okay. And Representative Abrams.
Another question about the occupancy. I know this addresses ownership, but it doesn't speak to rest homes and nursing facilities for those who have been previously convicted. Is there any interest in addressing that component for those who are confined to a space like a nursing home or a rest home, but who will not own, because usually admittance into those places requires that you release your own ownership?
This would not change the law on that, because this would apply to people who. I think what we're really trying to do here is address a limited situation, but an important situation. That is, people who have tried to comply with the law by making a determination as to where the prohibited area would be, and then making an investment by the purchase of a home in reliance on that, and then things change later. So, but this doesn't envision a change in current law with respect to those other types of individuals.
I guess a huge part of my concern about addressing residency without thinking holistically about this is, particularly given the aging population of Georgia and the co-location typically of senior facilities and in communities, we create a bit of an imbalance in the ability of those who may or may not prove sort of a predatory harm to community being put into a different category that creates safety on one side, but creates a very different set of obligations on the part of government on the other side. And so my concern is making sure that when we approach the conversation about residency, I understand the narrowness of the intent, but I do think that it's, as I've discovered in my very short time here, sort of once you open something, it's better to get it done while you're looking at it because getting back is really difficult. And so would just challenge us to continue to think about the larger issues that are associated with this.
And I think your comments have validity. And I would go back to to my response earlier about the classifications. I think it's just extremely important that we reenact the residency restrictions. And I'm very happy to look at the classification issue and that issue, but I don't want to slow down the process when we right now have none, when we have had them. But I'm happy to have dialogue with you on that.
Any other questions for the chairman? Not seeing any. I'll turn this back over, and one just came up.
And it may have to go to Jill, but was there any discussion or consideration given to hospitals, particularly children's hospitals, where minors congregate? Is that included?
I don't think that would be included on the list, would it, Jill? The list being defined?
No. For some reason in my mind no. I don't see anything medically oriented on the list.
And I think my response, Representative, would be the same as to that. That might be something that in a separate measure we might want to take a look at.
Just thinking particularly about what used to be Eggleston.
Yeah.
Healthcare housing.
Right. Yeah. Thank you.
Thank you, Mr. Chairman, for bringing this legislation forward.
Thank you, Representative Bearden. Thank all of you again for being here today. Any comments of a general nature from members of the committee? I know. Thank you. If not, let me sort of tell you, of course, we convene on January 14, and it's the chair's intent at this time to take up early and take up and have on the agenda that week, in case those of you need some reading to do over the holiday break. It would be House Bill 908 that we just discussed. Chair also intends to take up Representative Bobby Reese's House Bill 301 early in the session, and also I would like to take up in the first week or certainly first week or two Representative Benfield's eyewitness ID bill. I just developed a hearing problem up here with Representative Levitas. Any other matters to come before the committee today? Excuse me? You want a gun bill the first week? We'll get Representative Bearden back down here. I'm sure he can take care of that in a hurry for you, Nikki. I want to wish all the members of the committee a very, very Merry Christmas and a happy holiday season and a happy New Year, and thank you for your friendship, and I look forward to a great session next year. Meeting's adjourned. I'm sorry. Oh, yeah, members of the committee, we got lunch coming up between 11:15 and 11:30. Is that here? In this room. So you'll be in recess until then.